welcome everyone. I am Rumpa Banerjee and I'm really happy to bring an exclusive session for all our members at IPRS. This session is part of a series that we have put together for our members. We know that all of you are completely involved in your creative process and creative work, but there are a lot of other aspects of music that you cannot ignore as a creator and a publisher. Hence, we are here to help you. At IPRS, we are glad to present this exclusive knowledge series for our members, which we have titled or named as Learn and Earn. We want you to know and learn all that is required to help you create better and, of course, earn better. So now coming to today's session, what you create as authors, songwriters, or composers, these are precious intellectual property. And there are many rights related to it. One very familiar term you must have heard always is copyright. The songs and the music that you create are protected by copyright. But then what is copyright and how is copyright governed? Who are the rightful owners of copyright? When is copyright infringed? What are the different rights related to music? What are your rights as a creator? And what is the copyright societies? I mean, copyright societies like IPRS you are a member of? Oh, I think it's too much. No worries, because we have with us one of the most knowledgeable personalities from the music industry with us. I consider him as the encyclopedia of the Indian music industry. However, he loves to designate himself as the dinosaur of the music industry. So here we have with us our much admired and revered Atul Churamani sir. With nearly 35 years of experience in the music industry, Mr. Atul Churamani, Managing Director, Turnkey Music and Publishing, is an ocean of knowledge on the subject and the go-to person for all your queries on music and the business related to it. Welcome, sir.
Thank you so much, Rumpa. That's a very kind and flattering introduction. Just very, very happy that you're doing these sessions. And it's a lovely name, Learn and Earn, because if you don't do the basics correctly, then the earning doesn't happen the way it should. So really delighted IPRS is doing this and even more privileged to be a part of it. So, very happy to share whatever I know.
So Atul said today we will be exploring a topic that is of utmost importance in the music industry and for any creator and for any member, of course, like who are part of IPRS. But at the same time, it has a lot of preconceived notions and fallacies around it. But as I said, that we are happy that you are here to explain each of it, the minutest of details of this topic. So to cut the long story short, what exactly is copyright and how to define copyright?
There used to be a joke doing the rounds that Bapida, the late Bapida, had said copyright is the right to copy. So, it was a very prevalent joke some years ago. But actually that's true. That's really what copyright is about, what it means. Copyright means the right to copy. And the reason for copyright is creators are creating something which could be called intangible. Because when you have a composition or a lyric, for example, it's not tangible because it's not the piece of paper that you're writing the lyrics on. It is the lyrics itself. Now, I can recite the lyrics, but where's the copyright of that? And the fact is that the term copyright, being the right to copy, also has an extension meaning the right to copy for money, for the commercial purpose, right? So anything that is a copyright is always a copyright so that it earns the person who's creating it or owning it. They're able to earn money off that copyright, right? That's the reason for copyright. So very simply put, copyright is the rules under which people monetize their creations.
So do you mean that like through copyright, there are some rights vested like for the creators and they can utilize those to like monetize their creation? And then who governs it?
There is intellectual property. So copyright is part of intellectual property. Intellectual property spans a lot of different things like designs, patents. There are a lot of things, artistic works, So you imagine that these things have some kind of a registration, and somebody owns them, etc. It's all governed under pretty much the same set of rules. Copyright is just one part of intellectual property. Intellectual property is governed by WIPO, right? The World Intellectual Property Organization, that puts down rules and makes treaties on certain different kinds of rights, which all the countries sign to. So for what's important for, let's say, IPRS and composers and authors is what was the Berne Convention back in 1886, when the rights of composers and lyricists were recognized, and they were put down in a charter which was signed across the world by several countries, including India. So we all recognize the rights in the composition and lyrics, and the rights within those are exploited to earn money for the creators. So that's how it flows.
There is a body which is an international body who are formulating rules, and they are laying it for the benefit of the creators. But when I hear it as a kind of a representative of the creators or a creator myself, I get so kind of nervous because I don't know what is happening where, and how do I keep a track of it, that what is being made for me and how it will benefit me, because I don't read those kind of journals or books. And I'm very far away from the legalities of this business. I know only my creation.
Yes.
And so as a creator, who kind of helps me, and like, what do I do?
When the creators are focused on creation and letting this part of the business be dealt with by people who are specialists in that part of the business. Because if you're going to start dividing your time between wearing a creator's hat and wearing a businessman's hat, something is going to suffer. You're not going to be able to do the greatest business, or you might not be able to spend as much time on your creations as you should.
So true.
So when it comes to music, right, there are three things that have copyright in music. One is the composition, one is the lyric, and one is the sound recording. Okay, so these are the three pieces of creation in music that have copyright. And these are the three things that get monetized under the copyright laws. So I just want to also mention to anyone who's watching, I'm not a lawyer. I've never studied law. I've just been in the industry a very long time, as you said, right? And you pick up these things along the way. And, as you deal with situations and contracts and, your understanding, it's just so fascinating to think that copyright is only common sense. There's nothing to it. It is just common sense. You don't need to be a lawyer to understand copyright. You just need to be very aware of some very simple processes in the music business, for example. Now we're talking about music. So how is music created? How are those rights? Where do those rights emanate from? Okay. So let's be clear that the objective of creating music is to create a song which is listened to by as many people in the world as possible. I don't think any creator wants to not achieve that. So you're creating something which the world needs to listen to and admire. Okay. And it should earn you money, of course. So let's assume that we have a composer like Anu Malik, and we have a lyricist like Javed Saab, who get into a room to create a song. Okay. Now, what is the first thing that happens? Anu creates a composition, Javed Saab writes a lyric. And let's assume it is something Panchi, Nadia, a song. Now what happens? You want the world to listen to it. You have a composition and you have a lyric. What's the first logical thing that you need to do?
Like make this together and like record that song and make it. Correct. And someone has to sing that song as well.
Correct. So the first thing you have to do is to record the song. So the first copyright in a composition and lyric is the right to record the song, the recording right.
Okay.
Okay. And you can record that song today. So when Panchi Nadia was done, it was Sonu who sang it. Sonu and Alka, I think, they sang that song.
Yes.
But you re-record it today, what is happily called cover versions or remixes or whatever. And history is witness to the fact that big songs, popular songs are recorded over and over and over again. They don't even need to be big. You've had a lot of songs which were not so big by the original artists and creators, and then they were re-recorded later and became huge. So the fact is that the first right is the recording right, the right to record a composition and lyric, which could be recorded for the first time, or it could be recorded over and over and over again. So I call it the recording right and the re-recording right. So that's the first right that you have, right? So now Javed Saab and Anu Malik have taken Sonu and Alka into the studio, and they have recorded the song. Okay. So we have a composition and lyric, and we have a sound recording now because there's a record. Now what do we do?
Now we
want people in America to listen to this song. Now what do we do?
Yes. So now, like, somebody is singing it, and then now we have to publish it. We have to kind of send it out through different platforms for people to listen to.
And to send it out, what do you need to do?
Like, copy it somewhere in any form.
Right. So here's the word copyright again, magically. You will make copies of that recording. Right. So in the old days, when we had physical product, it used to become several LPs or several cassettes or several CDs. Today, it becomes several files which go out to different computers.
Right.
So what you have done is you have reproduced the work. You've made a copy of the work. Okay. So both for the sound recording and for the composition and lyrics, because now the composition and lyrics are sitting inside the sound recording. So every time you make a copy of the sound recording, you're making copies of the composition and lyrics. So the second right is the right to make copies, the reproduction right.
Okay.
Okay. Now, if you make copies, and again, it's easier to understand with physical product. So back in the day, at the music labels, we used to get, let's say, cassettes manufactured in a factory, and those cassettes were put in the warehouse.
Okay. Right. That was simple, and it was like in front of me. Yeah.
Now, what happens next?
Now everything is digital online. I have no track of where it is getting copied.
But the principle remains the same.
Yes.
So when you've made the copies, you need to distribute the copies. Okay. So whether it's a physical product that you put in a vehicle and take it to several retail stores, or whether it's a digital file that you send out to different platforms, you're distributing the reproduced files.
Right.
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 So the third right is your sale and distribution right.
Okay.
Okay. Obviously, because again, just going back to physical product, it's easier to understand. So once the distributor has put the cassettes and CDs in the shops, right, he's distributed them, and then someone needs to come and buy them. The consumer needs to come and buy them, right?
Right.
So right of distribution and sale is the sale and distribution right. So you recorded the composition and lyric, you reproduced it, you distributed and sold it. Correct?
Yes.
Okay. So far, all logical?
Yes.
Now the critical question. When so many songs are being made every day, how does the consumer know that he wants to buy that product?
Yes.
So there is the public performance right, because people say marketing, marketing, marketing. Of course, marketing. The best way to market music is to make people listen to it. So play it on radio, play it in shops and establishments, right? People listen to the song and they consume the song. So in the old days, they bought physical product. Today, they go to Spotify and Apple and Ghana and Savan and they stream it because they like that song. They're listening to it over and over again. So they're consuming it. So there is a public performance that you need to make of the song. A, when you want to sell it, because if I make people listen to it, they'll consume it. And then for the platforms and radio stations, etc., once it becomes popular, they want to play it. So radio pe bajega, TV pe bajega, it will play in malls, it will play in shops because it's a popular song. That right is the public performance right, because you're playing the song to the public.
Right.
Right? तो वो आपका चौथा right हो गया. See, it's all very logical.
Yes.
Record it, copy it, distribute it, play it on radio, play it on television, play it in establishments. Okay, so that's basically what you do with every song. Now what happens, especially with the composition and lyrics, is that a filmmaker hears the song and he says, yaar ye gana to bada acha meri picture mein fit aata hai. So let's assume that is Subhash ji. So Subhash ji comes and he says, I want to record this song and put it in my coming film. The right is the synchronization right. So everyone talks a lot about synchronization. What is synchronization? Synchronization is marrying the song, the composition and lyrics with a visual that did not exist previously. Okay. So you've synchronized the work with a visual. That is the synchronization right.
So here I would like to interrupt. A lot of times we see a lot of ad films in which we have some popular like the movie music or the movie songs playing. So is it also synchronization of the song?
Absolutely. And what happens very often is that for the situation or for the product, they want to make a few changes. They want to change the composition a little bit. They want to change the lyrics a little bit to suit the. So what are you doing? You're making an adaptation of the work.
Right.
Change anything in a work. So a lot of people think that मैंने तो उनका गाना लिया नहीं, मैंने तो change किया हुआ है. So I don't need to take permission. Ulta. To change something, you specifically need permission because you're working with something that was already existing and you're making changes to it. So that right to make that change is called the adaptation right. And the adaptation happens in the composition and lyrics. For very many years, we had rulings from courts about adaptations and versions and arrangement and changing of singers. That is not an adaptation. See, if I'm re-recording a song, obviously I'm going to change the arrangement. Obviously, I'm going to change the singer. So the adaptation is really in the changing of the composition and lyrics because that creates a new work. It's an adapted work, right? So the next right, the fifth right in the composition and lyrics is the right to adapt. So you make an adaptation. And then of course, Subhashi wants to make the movie in various languages. So the other right then that follows is the translation right, because you're translating the lyrics from, let's say, Hindi into Tamil and Bengali and Malayalam and Marathi. So the translation right is the next right in the bundle of rights with composition and lyrics. And once you have an adaptation and a translation, then you have to start the whole process over again. You have to go back into the studio, you have to record it, you have to reproduce it, you have to distribute it, and you have to publicly perform it. And that is your entire bundle of copyrights in composition and lyrics. Okay. And on this side, on the recording side, you can't record a recording. You can only reproduce a recording. So your first right in the recordings is the reproduction right, then the sale and distribution right, then the public performance right, and the synchronization right is slightly expanded in sound recordings because you can also sample them. People are very aware of sampling now. You take a portion of the original recording and you put it into a new recording. So the Copyright Act calls it incorporation of a new recording of the original recording in a new recording. Okay. So that can work for a film.
Is there a single term to that, or you define it in that way?
It's defined like that. Incorporation of the recording in a new recording, which can work in film also because a film is a recording in itself, so to speak. So the synchronization of the sound recording and the sampling of the sound recording is really the other right in the sound recording. So sound recording has only 4 rights. On the composition and lyrics side, we have 7 or 8 rights.
So like before, like going forward with the session, so I'll just quickly summarize the rights that you have spoken for the lyrics and the composition, because that is what will matter mostly for our members. Is that first is like you are giving the recording right, that you are giving the right to record the song. Second, you're giving the right to reproduce, because if you don't reproduce or kind of transmit it further, people, like how will people listen to it? Then you're giving the distribution right, that you're going to different platforms to make the song reach out to as many audience possible. Third is, which is you like very nicely defined, that now people need to listen to, but the moment a person is listening to, it is becoming public performance of that music. So it entails public performance rights. Then you also have the adaptation rights and you have the translation right.
Absolutely.
So these are the 6 rights bundled under the copyright, which is given to the creators of a like particular song or a music piece of music.
Bang on. And there you go. That's copyright. That's copyright in your composition and lyrics.
So you had mentioned one term called intellectual property. So property, we are all familiar with. The moment we start earning, we all want to have a property of our own, apartment or a house. Or so how is intellectual property similar or different to a property that we know in our daily life? And what are the laws governing an intellectual property? Is it different from a real life property or a realistic property?
So, I mean, without going too detailed into it, it's simply, the recognition of your ownership in a work, your authorship or ownership in a work is really what intellectual property is about. So you don't need to, when you buy a house, for example, you have to go and register it. There are many, government formalities that you have to undertake. Copyright kind of recognizes, if I release it, that I own it or I have created it. It is almost like a stamp of ownership, the fact that you have put it out. That's what intellectual property laws do, because they govern a lot of stuff which is non-physical in nature. So even people ask about unreleased works. Can you register an unreleased work? Yes, now you have an intellectual property office, the registrar of copyrights, right? You can register unreleased works over there.
Right.
So intellectual property is really to recognize, as I said, ownership and authorship, and under those laws, remuneration of your creations. Number one, the fact that you've put it out, right? It's been released with your credits, that it's in itself accords you some form of protection, right? So tomorrow, if let's say someone steals your song, the fact that you released it, let's say 6 months before he did, that is proof enough that you are the author, that you are the owner, creator, author of the work. The second thing is that you actually don't need to register all your work with the Registrar of Copyrights if you are registering the works with IPRS.
Okay, yes. So, this is also one question we get from our
correct. So do you need to? It is critical to be registering your work with IPRS, because in the absence of that, you will not earn anything. So the first step is to register with IPRS. And if you so want, then you can also register the work with the Registrar of Copyrights. Where Registrar of Copyrights registration helps, definitely, is in a court of law. So tomorrow, if something comes up, you see, if I'm a very influential member of IPRS, and I can influence IPRS, whatever, there is always a suspicion that I could maybe manipulate something. Whereas when you get a government certification on something, a judge will look at it and he will take it, let's say, with more credibility than he might on an IPRS registration. So I could have been slack in registering my work with IPRS, right? Does that mean that it doesn't get recognized? No. So a lot of people say, send a letter to yourself, send the composition to yourself, and this, that, and the other. You don't need to do all that. What you must do as a practice is, when you create the work, when you release the work, register it with IPRS. As simple as that. And if you want to be doubly sure, then register with the Registrar of Copyrights. That's it. You don't need to do anything else.
Great. So this is one more motivation for all our creator members and who are yet not members of IPRS. Register with IPRS so that you don't need to worry. Just register your works with IPRS and they are kind of protected. There's a guardian looking after your intellectual property.
Let's back up a little, yes, a little bit to the fourth copyright we were talking about. Okay, so the public performance right is where an IPRS fits in. You see, when it comes to public performance, what constitutes public performance? Public performance is when the song is played in establishments, shops, malls, restaurants, barber shops, you name it. Songs are playing everywhere. If I'm a creator, how can I collect that money from all these establishments? Okay, that's one. Second is, there are 385 FM radio stations today, and there are 420 all India radio stations. So someone has to collect money from the radio stations to pay the creators. Similarly, we have 900, almost 900 television stations, plus we have 36 Doordarshan channels. Okay, there is money for creators to be collected from there. Now, can you imagine one creator who may be creating, I don't know, a song every fortnight, trying to go to all these places and collect his money? You can't do it, right? Not possible. So therefore, you have a collective like the IPRS in India, the PRS in the UK. You have 3 societies in the US. They collect for creators and owners of the work, who are the publishers. They collect money from all public performance that happens in establishments, radio, television, anything that is defined in public performance. So that is why IPRS is so critical, because that's where the money lies.
So my music is also playing abroad. So that is also what IPRS is collecting for me from.
Absolutely. So all copyright societies globally are governed by the nodal body called CSAC, which lays down all the rules and regulations for copyright societies. And copyright societies, when they're set up, have to apply for registration. CSAC sees that they're compliant with various things and then gives them registration. So you become part of the reciprocal network, which means that any song that is played in any country where there's a copyright society, a recognized copyright society, you will get that money in your home society. You can register with one society in your home territory, which is always the best place to register your work, and you will collect money globally.
Wonderful. So I just need to rest in my cozy corner on my studio or music room. Let me focus on making music and let IPRS do all the legwork.
Absolutely. So, go back to the start of our conversation when we said that the creators should focus on creation and let the business be to other people. So there are 2 entities that creators need to deal with. One is the copyright society. The second is a music publisher, in case they don't want to even make the effort of registering a work every time that they create it with the society. And there are other benefits of publishers as well. You see, one, what we call administration of your work is what happens at the society level. So registration of the work, automatic accrual of royalties that come from the digital service providers, from radio, from television. IPRS is licensing and collecting from there, and it's distributing those royalties. So that is the administrative part of it. Number one, they take over the administration so that the creators don't need to get into a registration every time. They just inform the publisher registers the work. The second and important thing to understand is publishers are part of a global network. Right. The publisher's business is to deal with users, potential users, and pitch the music, songs, the composition and lyrics for things like synchronization. So for example, in India now, you have a lot of OTT platforms that create audiovisual content. So you have Netflix, you have Hotstar, you have Z5, you have Amazon, etc. These people are making a lot of audiovisual content for which they are licensing music for sync.
Right.
Publishers are connected with those people. So when they have requirement of a certain kind of music, instead of sitting down on the internet and starting to look, they call the music publishers. They say, listen, here's a requirement that I have. Do you have something that you can license us? So in India, that happens, let's say, directly with the platforms, but this happens globally as well. So in every country, publishers are linked to producers, music supervisors who send in the demand and the requirements for their sync business, right? Now, if you are with a publisher has that network. So you have someone who represents the work in Australia, in Japan, in Germany, in America, so that when the sync requests in those countries come in, the music is showcased to the music supervisor or the production house, saying that, okay, if you want a piece of, let's say, Rajasthani music, here is something you can look at. Chances are it will get picked up. If you're not with the publisher, then you miss that opportunity, because where will they find your music? So my favorite example is, suppose Steven Spielberg wants a piece of music, right? He will call the music supervisor on the film and say, I want 30 seconds of a Rajasthani instrumental, this Rajasthani folk piece. They will go to the music supervisor and they will find it there, and they will to the music publisher, they will find it there and license it. Now, if you're not there, how will the music supervisor find it? How will he put it before Steven Spielberg? So if you don't have that connect through the publishing community, you lose that opportunity. If you have that connect, will something definitely happen? There are no guarantees in this, right? Because there are, as we all know now, 62,000 new songs coming out every day. The sync requirements don't keep pace with that, right? And the sync business is a pull business. It's not a push business. So if I represent, let's say, hip hop music, but Spielberg wants Rajasthani folk, I can't make him take hip hop. Right? So it's a pull business. What you can do is you can put it out in front of people. So if you're in the network, you'll put it out, and there could be a chance of something big happening. But if you're not in that network, definitely nothing big will happen.
True.
So it's really about the opportunity that you're looking at, rather than any kind of definitive business that will be done. But that's what music publishers do, So that is, and then of course there are little things that happen. So in a society, there might be a duplicate claim. There could be other issues which then get dealt with, and the creator is free to continue to focus on the creations.
Mm-hmm. So to understand it in simple words is that, like for a creator, it's always advisable to let the other person do the work he or she is like an expert in. Say you get like IPRS is managing your rights, a publisher is managing your creation, and helping you to earn more from like what you have created. Absolutely. So all the marketing, the negotiation, finding out the opportunities. So it's the publisher who is doing it because he is good at it. And then you can focus on your own creation and just like have those kind of relationships with the right people in the industry. That Absolutely. Is how I think it helps the creator.
Absolutely.
So one thing which we are currently noticing in the past couple of years is that mostly with COVID, when a lot of people went into the digital platform, they were performing their own music and all. So we have seen a shift from where earlier creators or like a songwriter or a composer used to be a songwriter only. A composer used to be mostly a composer, but now a lot of creators are also getting into performance space and are becoming performers themselves. So you have very nicely explained the creator's rights. Are there separate bundle of rights as a performer, or what are the rights that are like associated with the performer?
So what we've been talking about, Rumpa, really is from the IPRS and composer-writer perspective, composer-author perspective. That is all part of the publishing business. Then on the sound recording side, we touched upon the rights, but the sound recording business is done by music labels.
Yes.
Composition lyric part of that business is done by music publishers. The sound recording business is done by music labels. So the relationship is sound recording, music label, and artist or performer. In the Copyright Act, they're defined as performers. So artists are performers. You could be musicians, you could be singers, but basically an artist, a performer, signs with a music label and creates the sound recording. The publisher signs with the composer and lyric writer and creates a composition and lyric. So there are two parallel streams that run parallelly. So the rights that we're talking about now pertain to the performer, to the artist. and they have something called the performer's right. Now, in India, prior to 1994, we didn't have a performer's right. Then in the 1994 amendment, they put in a performer's right, which was for only 25 years, and it was a non-remunerative right.
Okay. So what?
So that basically, I think, and this is my conjecture completely, I could be wrong, but I think what happened by about 1994 was that a lot of private performances of artists were being recorded and being put out without permission of the artist. So there used to be private shows that were being done. The person organizing the show would record it and put it out. The 94 Act, because it recognized the performer's right, made it mandatory for a performer to sign off before a recording was released.
Okay.
But there was no talk about money. In 2012, they extended that. They made the performer's right 50 years. And they said that the performer's right is a remunerative right. Okay? So the performer, apart from giving his permission, also has to get a consideration for his work.
Right.
So the performer's right would be complete. You'd have the performer's right when the performer allowed you to release the product against a consideration. So that's what the 2012 amendment has done. It has also recognized the rights of performers. And that is how a performers' rights society has also come up, called ISRA, Indian Singers' Rights Association. So they now deal on behalf of the performers. And we are hoping that soon, this will also include musicians who are session musicians. So all performers start to get remunerated.
Great. So now my member or IPRS member who is also a performer then now needs to register with IPRS for the publishing rights and or the performing rights, and he has to also register with ISRA for the performance rights.
Yes, absolutely. And don't forget, there's a third piece of the puzzle, which is the owner of the sound recording, which at one point of time was assumed to be a music label. But in today's world, with a lot of independent music, artists themselves have their own labels or they self-release music.
Self-published works, yes.
That's right. So there is what is called the Neighboring Rights Society, which is the PPL, has been the PPL in India, which is the Phonographic Performance Limited, which actually collects for sound recording owners from the same places IPRS collects: shops, establishments, radio, etc. So the sound recording also gets remunerated when it is played. And now the performer's right enables them to collect a money of that performance also. Their performance resides in the sound recording. So when the owner is being compensated for use of the sound recording, the performer also gets a share.
Right. So in our members, we have creators who are writing, composing their song, they are performing their song, and they are also publishing those songs through their own YouTube channels or their own channels or like record companies. So in that case, they have to become a member of IPRS, they have to become a member of PPL, and also a member of ISRA to ensure that the monies keep coming from all the sources possible.
Correct. So, today we live in a fragmented world where there are multiple platforms and multiple usages of music that are happening. And each usage under the Copyright Act can be remunerated. So the more you make that effort of registering the work with the different bodies, the chances are the greater money you will see.
So you mentioned about one thing, that sound recording, and it's a separate entity of this music business. So at IPRS, we have a lot of members like a Saregama or a T-Series, Sony Music, who are music labels, and they are enrolled or registered with IPRS as publishers, as publisher members. So then how do we I'm getting a bit confused on this part, because you said they are like people will collect for them, but here we are also representing them as music publishers. So can you just explain and this better? Where is this differentiation, music publishing and music labels?
So, this has a bit of a historical perspective to it, because in India, we started our industry in 1901 with the Gramophone Company of India, which is today Saregama. which had a recording studio. It had a record pressing plant. So songs used to be recorded in their studios. The LPs used to be manufactured in their plant. And Saregama, being the only music entity in the country, used to then take that music, the LPs out into the stores, sell them, etc.
You mean that like the dog with that gramophone, the his master's voice?
Yeah. So that was the origin of all music companies. They started as companies manufacturing gramophones. And then to sell the gramophones, they made records, so that's the way the business evolved worldwide. But it was about manufacturing and distributing the recordings, which were being recorded in their own studios. So they were the only music entity, so to speak.
Yes.
And then Mr. Saha's company came up in 1932, I think it was, the Indian Record Manufacturing Company, which did pretty much the same. In 1969, Polydor entered India, and they did the same. CBS came in 1982, which is today Sony Music, and they did the same. So we had a succession of record labels. Then T-Series, Tips, and Venus came up, also manufacturing records and creating recordings. And because there was no other entity doing any kind of business in music, these people owned the underlying works as well. So they owned the composition and lyrics apart from the sound recording. So it became all the rights under one entity. Whereas in the West, what happened was the record label and the publisher, even if they were owned by the same company, they were separated. And it's a very simple logic. If you have a recording, which is a unique recording for a record label, then only that one recording is being sold. So the record label makes all the money. But if you're a music publisher and you own that composition and lyric, the more recordings that you have, the more money you will earn.
Right.
Right? So it's in the publisher's interest to have more and more and more recordings of the same composition and lyric. Whereas in the record label business, a unique recording makes money for the owner of that recording. Okay.
Right.
So there is some sort of an inherent conflict in the record label business and the music publishing business. So therefore, in the developed markets, they very quickly recognized that fact and they distributed the work between the two entities. So one record label and one music publishing. So you have Universal, which is the biggest company in the music industry, which has Universal Music Publishing as a publisher, and it has Universal Music as the record label. Sony has Sony Music Publishing and Sony, the recording company. Warner has Warner Music and Warner Chappell. So these are entities that are divided. Some publishers have no record label like the one we represent, which is called Cobalt Music. There is no record label. It is a pure play music publisher. In India, however, it's the record label that owns the underlying works. So they have two businesses that they're running. They're running a record label business and a publishing business. And that's why they will register the composition lyric part of it with IPRS, and they register the recording part of it, let's say, with the PPM. But they are running two different businesses. And when they issue a license, so if someone wants to use the original song in an ad, they will issue two licenses now, one for the sound recording, one for the composition and lyrics, which then comes into IPRS so that the composer and the author of that work get their 50% share of the revenue. So one license divided into two parts, recording and publishing. The publishing part, then IPRS takes care by paying 50% of that money to the composer and lyric writer.
Wow. So here, like though Saregama is a music publisher and a music label, but their identity and role is completely different, like as a music publisher and as a music label.
Absolutely. Absolutely.
So like what I understand from the discussion that we like right now had is that then there are two distinct pillars of the business. Then one is entirely music publishing, composition, lyrics, the underlying works, and then you have the sound recording. And both kind of are kind of like catering to two different kind of business needs in the industry.
Absolutely.
Okay. So, so now that we have a kind of a bit of an understanding of the different rights, intellectual property, copyright, we are kind of heard from you. So some of the terms which we frequently hear and it's part of a lot of contracts and a lot of places, is that like one is performing right, one is mechanical right, like one is like synchronization right. Like you have touched upon this, but if you can just help to understand one after the other, suppose what is performing right, what is mechanical right, what is synchronization right, and because this session is from IPRS, what are the rights that IPRS as a copyright society or a like a society like IPRS, they kind of manage?
So, as I mentioned earlier, the reason for a society is because you're catering to a lot of users who cannot be handled individually by a creator or even by a music publisher. So, the very fact that there are so many establishments, I mean, that's the first place in which you need help as a creator or a publisher. So the public performance right is the first thing that the society takes care of. So they are talking about the public performance happening in establishments, which I was mentioning the other day. It could be up to 14 million establishments. They have so many radio stations, so many TV stations, just as a starting point, right? So the public performance element itself is so large that that right needs to be collected by the society. You cannot collect it individually, which is why publishers and creators need to be part of the society to make sure that they're collecting their public performance revenues. So public performance revenue is collected by the society. That's the first mandate. The second is what is called the mechanical royalty or the mechanical right. It is simply the reproduction right. And again, the concept of this is that there are so many multiple users, so many different places where your work is getting reproduced, that as an individual, it's very difficult to collect from everyone, right? So let's take DSPs, your digital service providers. Today in India, you have 9 major services. You have Deezer, which is still not entered India. That's a 10th. Then you have many homegrown services in different countries where Indian music is played. How are you going to collect? So you need, again, you need a collective which will go and do bulk licensing and bulk collections from those platforms, right? So the performance right and the mechanical right and those royalties is what a society collects, because it is just too difficult, too many users for an individual entity like a publisher or an individual like a creator to license directly. So the society is almost like a charitable organization, and they're all not-for-profit organizations. They don't make a profit. They're allowed to retain a certain percentage to run expenses, but they're not for profit. So it is almost like a charitable work being done for creators, because they are going out and licensing people too numerous for individual entities to license.
Sir, I'll just interrupt here. I will just want a bit more understanding on this. So when I say public performance, suppose I'm having a house party, or I'm having a shadi, like a wedding, and the music is playing there. Is it equivalent to public performance?
Yes.
So where does that line end from personal performance to a public performance?
So any playing of music that can be heard collectively is a public performance. So when you're playing it at a function, right, where there are a lot of guests, that's a public performance. When you're playing it at a radio station where there could be multiple listeners simultaneously, that's a public performance. Different from an on-demand service where individually I am choosing. So that's my personal thing. You asked about a private performance. That is a private performance because I'm choosing to play that song now. But when radio plays it, they're playing it at 9 o'clock India time, whether you're tuned in, you're not tuned in. Everybody could tune in at the same time. So your one play, one performance is going out to multiple people simultaneously. So that's the definition of the public performance.
Right.
So when
nowadays we also hear music in Ola and Uber. So is that public performance also?
Yes, because it's it's not an on-demand service. So let's just put it as simply as, can I choose the music I'm going to listen to? No, you can't.
It's coming to you. So nicely said. I had this confusion for very long. Coming to you. It's being beamed. It's being thrown to you. Yeah, pushed to you. So it's public performance, right? Mechanical rights. Mechanical in earlier days was very simple. I make a CD. I make a kind of an LP. I print it. I sell it. It's getting copied. Mechanical. In today's day, when there is no physical copies, can you help me understand that? How then the mechanical, how it is becoming mechanical and where all it is getting copied? Suppose if I'm hearing a music, say on Spotify, like where this mechanical aspect is coming.
So, we like staying with some terms which are historical. So for example, PPL, phonographic performance limited. When did you last hear anyone call a record a phonogram? So we just, as an industry, we stayed with it. It works. In fact, the Indian music industry today, the IMI, the rodal body, used to be called the IPI. It was the Indian phonographic industry.
Oh my God.
Because that was the record label business, the phonogram. But we all realized that, listen, nobody understands what you're talking about. When you say phonographic industry, kisi ko kuch samajh nahi aata. So it's the Indian music industry, as we called it. But the fact is that, there are historical terms. So the mechanical will always be called a mechanical, I'm sure. It's really the reproduction. So when we were talking, I was saying that it's a reproduction. In the old days, it was a mechanical reproduction. Today, you can call it a digital reproduction, but it's basically a reproduction. And when you reproduce the file and you store it on servers, right? That is really the copy that you're making. So there's a copy that is made.
Also, when I'm downloading on my phone and I'm storing and listening to it, it's a copy being made on my mobile.
It's a copy being made, right?
So hence the mechanical right also.
That's the mechanical right. And like I said, that's where IPRS comes in, or any collecting society, because multiple users making multiple copies, difficult to license directly by any rights owner.
So synchronization right, you have already explained in depth in our previous discussions and during start of the session. But just to touch upon, because we are kind of explaining performing mechanical. So the third big right is the synchronization right. So now my song gets copied, laid on videos, on different ads and all. So there is where the synchronization right comes into play. But does IPRS also administer synchronization right or manage synchronization rights?
So, and it's interesting because in this conversation, I've realized, I'm a genius, so I kind of learn every time I talk. So this whole business about IPRS being relevant to people because there are multiple users. That's what explains why IPRS doesn't handle synchronization. Because it's not that there is constant usage in sync of a work. It's an on-demand, like I was saying, it's really a buyer's market over there. There is a specific need at a specific time for the sync. It is not something that's ongoing. It's not something that's difficult for an individual copyright owner to do. So therefore, there is no need for a society to handle sync. In some societies, what happens is that some broadcasts, television broadcasts, right? There is a sync right that is given for general usage by a lot of publishers. However, if there is a specific event, so let's assume that we have the Oscars and they are being telecast, but the TV station has a blanket license for music from the society. But for the Oscars, it might be charged separately for the sync because those performances in the Oscar are not part of the general license that is given by the society.
So this brings a very interesting question in my mind. Oscar is happening on ground. There is an event. So there's a public performance also?
Absolutely. Absolutely. So you have to, so the first thing is that without the ground performance, there's nothing else. So first that ground performance needs to be licensed. Then it could be televised. It could be a television show, which is a simultaneous broadcast and then nothing. Or then it could be recorded and put up on a platform like YouTube later. So there are several licenses that are required depending on what you want to do. And each one is handled actually by IPRS, because like we said, there is that whole thing of multiple usages. Where am I going to go and license a ground performance at the Oscars?
So this brings again that one more relevant point, that let me create my music and let me join IPRS or any copyright society, like depending on the country I belong, let them get all the licenses and monies for me.
Absolutely. And the other very important thing, Rumpa, for all creators and publishers also to do is that IPRS is collecting from a lot of live shows. There are live shows, and in the pandemic there was nothing. Now we are seeing it coming back with a vengeance. If you're a creator, a singer-songwriter, or a music publisher, if you can, for every performance of the artist, put in a cue sheet. So it's when the organizers take a license from IPRS, ideally a set list should be sent into IPRS, so that if IPRS is, let's say, collecting 5,000 rupees from there, that 5,000 rupees is going to the songs that are actually being performed.
Right.
Now, in the absence of cue sheets, and 99.9% of performances are not supported by cue sheets, IPRS has to develop its own distribution policy, because by law, you cannot sit on money for more than 3 years. And 3 years is a long window for someone who did a performance, didn't have time, came back, chalo, then later I put in my set list. So I have a 3-year window in which to say, this was the date, these were the songs, etc., so that the money gets allocated as accurately as possible.
Absolutely.
Otherwise it goes into a distribution scheme, and in a distribution scheme, it goes by percentages. So naturally, the more popular composers and publishers will take away the larger chunks of the revenue. So it's something you hear about all the time when people are complaining, "Arey yaar, wo to Bollywood music sab kuch paisa le jata hai," and all that. It has to, because that's the most popular form of music. Even if you read the latest reports on the music industry, the FICCI report, Bollywood share has come down, but it's still by far the largest.
Right, absolutely.
So when you have a distribution scheme, they're going to get the bulk of the money unless it can be identified as yours. So anytime anyone is doing a performance, as a habit, inform your publisher or directly go to IPRS and put in your set list.
Right.
Help IPRS in accurately determining what songs were played so that the correct people are getting paid.
Right. And as you always say, with this like non-film music gaining popularity, so it will become even more important for these public performances to kind of have a cue sheet. Because
exactly. And a lot of independent artists, so we've had these conversations a lot in the past, when an artist says, but I'm playing my own music. So how does it matter?
Right.
Because you are not paying for the license, the organizer is paying for the license. That's additional money. So if it's 5,000 bucks, like I said, that money will come back to you. The organizer will not pay you that money directly.
It has to be with IPRS, absolutely. And so, in a way, it is kind of not only helping you, it is helping the music industry and the community at large.
Absolutely. Think about the fairness of it. So if I'm a composer today, right, and I'm saying that only I'm singing my song, so how does it make a difference? Sure, you could be singing an R.D. Burman song. Don't you want royalties to go to him? Many years down the line, somebody could be singing your songs. So then wouldn't you want that money coming to you? So in the fairness of things, when you do a performance, always put down a set list and insist that the organizer deposits it with IPRS.
Right. So Atul sir, we have already spoken a lot about the role of IPRS and how it benefits the creators and the publishers of music. But just to sum up, and we cannot end this session without, because I'm also curious to know that where and when the idea of a copyright society originated from, and exactly if you have to summarize what is the role of a copyright society and how it benefits and the creators in the music industry.
So of course, I mean, the famous story is about the Frenchman who went in for a cup of coffee or a meal to a restaurant, heard his music being played there, and walked out without paying, saying that if you're not paying me for my music, then I'm not paying you for your food, right?
Such a kind of a strong approach and attitude. That's the right attitude.
Well, exactly. Otherwise people don't listen. So that's supposed to be the origins of how these copyright laws came about, and the Berne Convention in 1886, etc., recognizing these rights. But like I said, it's a convenience for creators and a way to get remunerated that these societies came up. And also because a few years back, you'll remember we had one Doordarshan and All India Radio. That's how every country used to be. And then as technology develops, media develops. As media develops, usage of music grows. We have digital platforms today, when we have multiple digital platforms. So every time music is being used, I use the word fragmentation. This fragmentation of usage, some of it is very, very valuable, and that's what makes up the bulk of the revenue for the industry. So if you don't have your societies in place, if you don't have tariffs in place, now if I'm setting up a new streaming service and I want to know what it will cost if I were to play music, I go to IPRS website, I check, I see there's a tariff over there. I've understood, so it's very beneficial all around for people who are doing business, for people who are creators. It's helping get music licensed at a fair value on both sides. There's convenience because as a user, I can't go to multiple creators and say, give me a license to play your song. So I go to an IPRS. So it's actually the very hub of the business, especially on the publishing side for creators. You need an IPRS to license and collect your public performance and your mechanical rights. So that's the very basics of it. And all the revenue that will come to you on an ongoing basis will come to you via the society. You may or may not get a synchronization for a year, 2 years, 5 years. You will definitely get your royalties from IPRS.
And also, like your copyright is also there, like 60 years after the demise of the creator. So in that way, your family is also benefited.
Oh, absolutely. So, as someone said just now, your royalties that come in from IPRS are really your salary as well as your pension. So, and that flows down to your family. So the life of copyright, and this is something, the term of copyright changes, but in a sound recording, for example, everyone says 60 years, in a sound recording, it is the release, 60 years after the release of the sound recording that copyright exists. But in the underlying works, in the composition and lyrics, it's 60 years after the death of the last creator. So if 3 people have created a song, it is after the death of the 3rd one, 60 years after that. So the life of copyright in a composition and lyric it could be up to twice the period of copyright in a sound recording.
So that means almost in a way, 2 generations might be kind of cushioned with a certain amount of income.
It's not just that. And you also have to understand that, everyone looks at, so the sound recording copyright is over. There are recordings that exist in our industry today, which are in public domain. 60 years have elapsed. Does that mean anyone can pick them up and use them? No. There's a Delhi High Court order saying as long as the composition and lyrics are in copyright in a sound recording, to use that sound recording, you have to go back to the owner of the copyright, of the publishing, and get a permission to use it. So that reproduction license is valid.
Wonderful. So like, can you just, like, before we end this session today, can you just highlight a bit on that copyright amendment which happened in 2012, and what are the things which kind of safeguards today's creators? Because the things which you said, that these were the verdicts which came out, came out from time to time. So the latest amendment,
Yeah. So basically, what used to happen, and the industry has kind of grown on the back of film music. And there was a certain way of operating in the film music business where the producer of the film used to do a works for hire with the creators of the music. So they used to hire a music director. They used to hire a lyric writer. They used to pay them a one-time fee and own all the rights. Then they went and sold those rights further to a music label, either for a one-time fee or for a royalty that used to go to the producer, right? The composer and lyric writer never were part of the conversation between the music label and the producer.
Right.
So they were almost like a third party who had sold off their rights for a one-time fee. The thing is that it was fine at a time when there were no avenues for royalty earning except on the sale of records. And it works both ways. No? Sometimes a record becomes a big hit, so the writer would not have been able to get royalties, on the success of that record. However, in a lot of cases, he got a fee and the record wasn't so successful. So he actually got paid more than he would have got in terms of royalties. So it kind of evened out and people were not too unhappy and there was no other royalty coming in. All India Radio se kuch nahi aata tha, Doordarshan se kuch nahi aata. So there was nothing. But with development of technology and like I said, fragmentation, TV, radio, mobile, ringtones, ringback tones, everyone started feeling that, listen, we've written the music for a film. It's actually supposed to go into a film. And while it was going on to records like cassettes and CDs and vinyl and all that, we were okay. But abhi to yaar, there are so many ways in which it's being exploited and the composer authors are not seeing any upside over there. So then there was this move in 2012 saying that no matter what, the composer and author must get royalties. So that was the big amendment that happened in 2012 when the right to royalty became unassignable. So any contract that says they will not get royalty is a null and void contract. It doesn't. So on any exploitation of the work, the composer and author are supposed to get an equal share, which means a 50%. So 50% we understand. The society also distributes like that. 50% goes to the publisher, 50% goes to composer author. So it's an equal share. So that was the major change in 2012, which has ensured that all composers and authors get royalties in perpetuity.
Right. So like, can we just emphasize on this point, because we get a lot of times members call us and ask us that right to royalty cannot be given up. Even if you give it in writing, it stays with you. That is how the copyright amendment happened. So if you can emphasize on that point.
Yeah, so there was a little confusion about whether ownership can be assigned or not. Ownership can be assigned. So that there is one entity like a publisher or a music label that owns the rights. And it's easier to do business when one entity owns the rights because they grant all the rights, there's one negotiation that happens, etc. No problem. You can assign your rights to anyone. You are not the owner as a composer and an author. No problem. You're safeguarded because the law says now that you are entitled to 50% of the royalties that accrue on the usage of that work. So ownership could be sitting with a record label, but as a composer author, you are getting an equal share of the royalty. So you're protected. So there's no problem. Assign your rights, no issue. You will continue to get your royalties. Any letter that states, however, that you are not going to get royalties, that's invalid. The law says it's invalid, which is a big thing.
So we are guarded by the law of the land. So we should all keep in mind that your royalty is yours. You cannot assign your royalty to anybody else. One more very important point is that, which we kind of get to hear from our members, is that can someone else collect the royalty on my behalf? Or many people approach us saying that I am the publisher or I am the I'm representing this artist, so I'll be collecting the royalty on behalf of the author composer. That is also not valid as per the copyright, as per a copyright society, how it functions. A copyright society will always directly pay to the author composer who are its members. No royalty can never be routed through any third party. So that is, we should all keep in mind as members, as IPRS members, you should also keep in mind. And you should ensure that all your details are submitted with IPRS and it goes absolutely to you only and to your account. Thank you so much, Atul sir. It was such a wonderful session and we thank you for all the insight and the learnings that we got from it. And it was really fun listening to you. However, this is not just the only one session. We have many more sessions lined up with Atul sir. And please keep a please follow us. Please follow IPRS on Facebook, Insta, and Twitter. Visit our website for regular updates, because this is the series which we have launched for our members only, Learn and Earn. And through these sessions, we will try to help you, guide you, and update you on the different issues, topics that matters you and your creative journey. Thank you so much. We'll come back with our next session.
Thank you so much, Rumpa. It's been a real pleasure. And I hope these sessions are useful for people. And of course, if you have any questions, feel free to write into IPRS and we'll answer them for you.
Sure. So yes, that's also important. Whatever, like which topic you want to hear from us, what you want to know from us, please write to us at membership@iprs.org. We will organize those sessions for you, or we will come back to you with the required information. Thank you once again, Atul sir.
Thanks, Rumpa. Real pleasure.
And we look forward to hear you once again.
Thank you.